everyone, and welcome back to thorough newspaper analysis, which is presented to you by LawSikho. Let's see what articles we will be discussing today. There are two articles which are very interesting, and they are both from the Indian Express today. The first article is When Actors Cross the Line. So this is a very beautifully written article by Mr. Faizan Mustafa, who is who's an expert in the constitutional law, and basically it tries to talk about the anti-defection law. But then again, we have already discussed it in detail in the previous sessions. But in this article, a new dimension has been given to this very aspect, and the role of governor, and specifically talking about the governor of Rajasthan in this current case, has been discussed, and what should be the ideal role that he should play. Secondly, in the second article, what is abatement of suicide and how court determines if it took place. It is from the explained section of the Indian Express. As we recently know that the very famous actor Sushant Singh Rajput had committed suicide, and it is more or less regarding to that, and the legal whereabouts of the abatement of suicide have been discussed in this article. And then on the third, we have the News and Flash column, which is the LawSikho's own initiative, trying to bring together small and crisp, to-the-point news points, which are important for our prelims exam. Now, before we delve deep into this, let's just go through a small, a site on the LawSikho courses that we have for you. And at the center, we have the lot of the courses, that is the Judiciary Test Prep course, wherein we are providing all the aspirants amazing coaching and guidance in the judiciary preparation for their exam. And here we have free study material, which any of the aspirants currently, now you can go and visit the web page. We already have provided the link in the description box and can download for yourself this free study material, which is very accurate and appropriate for the exam requirements. We have various other courses for CLAT, other law entrances as well, or for All India Bar Exam, and various other courses, which can definitely be viewed on the official page of LawSikho. With this, let's see that what is the multiple choice question that we have dealing with the context and the discussion that we'll be following up with today. The question is, abatement of suicide is a criminal offense under which section of the Indian Penal Code? So many a times these types of questions directly hitting at these sections and provisions are also asked in the judiciary exam. So your options are section 304, second, section 305, third, section 306, or fourth, section 307. Do write down your answers in the comment section as soon as you're able to get the answer to this question in today's discussion. This is the descriptive question for the day. The purpose with which anti-defection law was introduced in Indian Constitution has not been able to be achieved. It needs to be refurbished to give teeth to its provisions. Basically, giving teeth to its provision means to make the provisions more efficient or effective in its implementation. Discuss. So the answer to this has to be written within a word limit of 250 words and 250 to 300 words at maximum, and it can be easily jotted down in the comment section below. We encourage that this be done because answer writing is a very important practice when it comes to judiciary exam. And then LawSikho will definitely make an initiative to review these answers. With this, let's quickly start with the discussion that we have for today, which talks about the constitutional aspects of Rajasthan's defection case that is really the burning topic these days. We know that in the last 6 years, 119 Congress MLAs have switched to BJP. Basically, why this topic of anti-defection and this provision of anti-defection is so debated these days is that since last 6 years, it is really a huge number of 119 MLAs from Congress have switched to BJP, and thus inflicting the cause of anti-defection law. Also, to study it in a whole scenario, on a scenario basis, between the time period of 1967 to 71, 142 defections took place in Parliament and 1,969 in the state assemblies. Basically, these complete facts need not to be kept in mind, but yes, the huge numbers should be kept in mind, because these are really big numbers when we want to, at one side, we want our government and a government system to be very stable, and on the other, we are seeing such great number of MLAs switching from one party to the another. Also, one thing that brings actually the entire question upon the anti-defection law is that amongst these, around 212 of the defectors who were actually the defectors under this law, they were still awarded with ministerial berths, or to say ministerial portfolios or positions. That is the very question as to how much is this anti-defection law effective in stopping this horse trading, or what we say ayaram gayaram system, wherein it's simply just like the trading is being done and one MLA easily switches from one party to another. And how much has this anti-defection law been really successful in stopping this movement? The anti-defection law was enacted actually to deal with ayaram gayaram, as the author in this article also quotes. It was like, it was considered that one MLA just comes and goes. So that is definitely very detrimental for the stability of any government. But the Rajasthan High Court's interim order in Congress MLA Sachin Pilot's case may have undesirable effect of diluting the anti-defection law. So basically, currently the High Court of Rajasthan has ordered to keep the things the way they are. So it has just said that the very situation should remain, and later on it might be the case. Let's just see that what are the later developments. But for now, it has ordered that the situation as it may prevail. It should remain the way it is. And let's see that what are the issues involved. So basically in this article, the author primarily focuses upon the role that the government should have played, but unfortunately the Rajasthan governor has failed to do so. And more particularly, the author says that he should be more of unbiased, impartial and more effective in his actions, but that has not actually happened. Let's see now how it has happened. Firstly, Rajasthan governor's question to the CM as to he will take the trust vote or the floor test or not are in violation of Article 174 and other established conventions. Basically, what happens is that under Article 174 of the Constitution, the governor has this duty. Now, we should know, being aspirants of the judiciary exam or any way otherwise related to the legal field, that wherever in the Bare Act this term shall is used, it leaves no scope or it leaves no gap for any discretionary output. Which means if there is anything shall that has to be done, that shall be done, it means that this particular authority has no any discretion on deciding whether it is to be done or not. If it is written that something shall be done, then it has to be done without any exceptions to it. And also in this light, Article 174 reads that the government shall from time to time summon the house or each house of the legislature of the state to meet at such a time and place as it thinks fit, but 6 months shall not intervene between last sitting in one session and date appointed for its first session, so and so. So basically the term shall here clearly signifies that here the governor does not have any discretion under Article 174, and thus it should not be his duty to actually question or ask the CM as to if he is willing or when is he willing to take the trust vote for that matter. We know, and now let's just clearly understand that what do we mean by the trust vote or the floor test. Basically, any executive, now in this case because the chief minister also comes from the legislature, but yes, now he is functioning as an executive. So basically that executive has to prove that still he enjoys the confidence of the members or of the members of the legislature, and then he has to prove his majority over there. That basically is known as the trust vote or the floor test. Basically, he has to prove the trust that the members have in him on the floor of the house, basically. So here, the governor actually asked the CM as to whether he will take this trust vote or not, and basically it was not at all desirable. He didn't really have to ask anybody for that matter, and he straight away should have convened the meeting, but that actually did not happen, and thus this judgment from Supreme Court case Nabam Revia, which was a 2016 case, it has been quoted wherein it was held by the Supreme Court that the governor does not have any discretion in this matter under Article 174, and that is why it shall be his duty to perform in this direction. Then, secondly, the governor is in violation of his oath under Article 159, because we know that under Article 159, the governor takes the oath wherein he promises that he will make the endeavors to keep the constitution intact and safe, and also to keep the other organs in a proper balance for that matter. But now, if he is not working in an impartial manner, and if in some other way he is showing any kind of discrepancy in his functionality, it definitely is a violation of his oath under Article 159. Then again, Supreme Court in the case of Hargobind Pant versus Dr. Raghukul Tilak in 1979 held that the governor is not an employee and he is not under the control of the central government. He is an independent constitutional body. Now here is the very purpose why governor is one person who is chosen one who belongs to no any political party, and he is you know what we say, by purpose, on purpose, he is one person who does not belong to any political party, does not have any political affiliations, and he should not even had any political affiliations in the near past. It was done so that he can work neutrally and he is not influenced by any of the political agendas or political whereabouts. But unlike that, and to the contrary, this is something which we are getting to see, that still the governor is not functioning independently, and he should remember that he is not an employee, he is a constitutional body in itself, and thus he is not bound by any such political whims and fancies for that matter. And also that is why he should work properly in the direction of his own oath and his own duties. Third, the High Court stayed the disqualification notice without any delayed or reasoned order. Now, basically, what is desirable is that the floor test or the trust vote should be conducted as soon as possible. Because also, as discussed earlier in our previous news analysis sessions, that if there is a considerable gap between any kind of defection and the floor test, it gives this party a chance to bribe the members, to bribe the MLAs, and then they would vote in favor of the party once they are bribed. And if this time period is shortened down, then it would definitely give a lesser opportunity to that party to be able to bribe any of the MLAs in order to vote in its favor. But in this case, here this delay has come without any reasonable logic. Also, the High Court stayed the disqualification of these MLAs or in Sachin Pilot, to talk about being in specific about Sachin Pilot, and this stay has come out without any reasonable cause as to why this delay has been made. Fourth, the jurisdiction of the court in matters connected with disqualification, because yes, also it has been held many a times that the court does not really have a direct jurisdiction and speaker is the one who is the final authority. Yes, of course, the speaker's decision is subjected to judicial review, but also the Supreme Court has held in various cases that even this judicial review has to be in a way limited, and the ultimate authority to decide upon the cases of defection is the speaker. Clause 6, Clause 1 of 10th schedule says that the final decision of this on disqualification is to be taken by the speaker. And then clause 7 bars the court with respect of any matter connected with disqualification. As just we discussed, that the ultimate authority to decide upon the cases of disqualification is the speaker as per the clause 6(1) of 10th schedule, and clause 7 also puts a bar on the court to decide into such matters. And yes, it can be done through judicial review, but not directly. Then in the case of Srimad Bhalasaheb Patil versus Honorable Speaker, Karnataka Legislative Assembly, which is a very recent case when there was this case of anti-defection in Karnataka in 2019, Supreme Court held that only a limited jurisdiction is available against the speaker's decision on violation of constitutional mandate, and thus the court should not think itself to be the ultimate authority for deciding the cases on disqualification. Then again, res ipsa liquitor, which is a very, very famous legal maxim, which says that the fact speaks for themselves and you do not really need any particular evidence for that matter. And as in this case, it goes against Sachin Pilot. As it is many a time stated that not only going against the party or the party whip is a condition for anti-defection, or just leaving or abandoning the membership of the party is the only condition. Rather, the conduct, to which in the Indian Evidence Act we construe as the circumstantial evidence, so that conduct is also enough to determine as to that particular member is under defection or not. And again, in this case, though Sachin Pilot has clearly said that he is not going to join BJP, but that just this statement cannot really put him off from the cause of defection, and his conduct some or the other way proves that he is in the liability of defection, and thus the facts are speaking for themselves. Then a Supreme Court in the case of Ravi S. Nayak, which was 1994 case, held that an inference can be drawn from a person's conduct in deciding whether he voluntarily gave up the membership or not. And thus, it's not just the direct evidence, but also the circumstantial evidence that we can gather would also, to say, signal towards any kind of defection. Then also the whip, as in 1999, the Law Commission's 178th report suggested that whip be confined to matter when the government is in danger, and otherwise it is not just that, because Sachin Pilot basically has said that his actions would not basically be deemed as defection, because at this time neither the House was in session nor the whip was there. But anti-defection talks nowhere about just this condition. Any circumstance also, that any action for that matter, that makes us believe that you are or that any member is in an act of defection would also be construed as defection. So this should be understood very clearly as to what are the pros and cons of the anti-defection law, and what can be the better ways of refurbishing this entire law to make it more effective. With this, let's get to the another article for the day, which talks about abatement to suicide. And as we know that the controversy around the death of actor Sushant Singh Rajput has taken a new turn in the as the actor's father has filed an FIR, and to say also a suit against his alleged girlfriend Riya Chakrabarti. Now in this case, the filed for abatement of suicide has been, so the cause of action or the charges are for the abatement of suicide. Now let's first understand that what actually is the crime of abatement of suicide. Under the Indian Penal Code, abatement of suicide also has been defined separately, and then again there is an entire chapter on abatement as well, wherein section 108 defines that who is an abater. Basically, a person abets an offence who abets either the commission of an offence, so either he is abetting somebody else to come. Basically, abatement means to incite somebody to do a particular work. That means abatement. So here, who abets either the commission of an offence, so either he is inciting other person to commit an offence, or the commission of an act which would be an offence if committed by a person capable by law of committing an offence with the same intention or knowledge as that of the abetter. Basically, anyone is a person who abets or incites, or he influences somebody or some other person to do something that is not right in the eyes of law. So that person would be considered as an abetter. And then here is the answer probably to your MCQ question, that section 306 of the IPC defines the abatement of suicide. So if any person commits suicide, whoever abets the commission of such suicide shall be punished with imprisonment of either description for the term, which may extend to 10 years and shall also be liable to fine. Now here is an interesting fact, probably all of you must already be knowing, that under the Indian Penal Code, commission of suicide, once done successfully, it is the only and only offence which, if done successfully, has no offence related, has no punishment related to it, but only the attempt of that that particular offence was earlier punishable. But now, because obviously once a person has committed suicide, he definitely is no more, and no punishment can be further inflicted on that person. But yes, if there is a case where another person has incited or abetted this person to commit suicide, then that person shall be punishable under the law with an imprisonment which may extend to 10 years or a fine, or as the case may be. Then the Supreme Court in the case of Sangar Bonia Srinu versus State of Andhra Pradesh held that although causing of death of another person is common between murder and abatement of suicide, but still they are distinct offences. So many a times it is also said that why isn't abatement of suicide called a murder? So what is the difference between murder and abatement of suicide? Which is a very potential question. It can definitely be asked in the mains as well. So here more attention should be paid to this concept. What happens is that the ultimate result of both murder as well as the abatement of suicide is causing death of the person. So ultimately what happens is that somebody dies. But here, the method of doing something varies significantly. In murder, you actually murder somebody, or say anybody, the offender or the accused, or whatever the case may be, murders somebody, and in that, the other person is not involved. But in suicide, you actually create the conditions for that person, be it may be physical, it may be mental torture, abuse, or any of the conditions wherein that person is himself compelled to commit suicide and take his own life. That is the very difference between the murder and abatement of suicide, and that is why they are two distinct offenses yet quite similar in their output. Then what are the main ingredients of abatement of suicide? So how is it actually understood by the court that a particular case is of the abatement of suicide? First, there should be suicidal death. As we said that in the case of suicide, there is a suicidal death done by one's own actions, unlike the murder. So suicidal death is determined is the deceased understood the probable consequence of the self-harming act and still does not intentionally, and still does it intentionally. Please mind, it is still does it intentionally will be there. So basically what happens is that here, for example, if a person is hanging himself from the rope or from the ceiling or anywhere for that matter, definitely that person knows the consequence of his actions, and then again still after knowing the consequences he chooses to do it. So that will be a suicidal death. Like for example, if you're taking an overdose of any poison of anything for that matter, you know that it is likely enough to kill you. So even after that knowledge and even after that conscience, you know that this harm can be inflicted to your own self, that will be a suicidal death. Then second, intention of the accused to abet such suicide. Now on the other side, when we talk about abatement of suicide, the other person whom we are referring to as being the abetter in this case should have some substantial cause or some substantial purpose behind abetting a person to commit suicide. Now this may be any kind of financial gain, personal gain, vengeance, or any purpose for that matter, but he should have an intention to abet such suicide. So the Supreme Court in the case of Sanjay Singh versus State of MP held that a comment of a statement uttered in haste, anger would not amount to abatement of suicide. And now this is a very, very important point which needs to be understood, that many times a person in fit of rage or anger or any kind of, to say, a big or huge feeling tends to say words that he doesn't really mean to. Like for example, there is a fight going on between two persons and one person says, yes, go die. So that doesn't really mean that the person actually abetted the other person to actually jump off the bridge or to commit suicide in any other manner. And if that person commits suicide now, then this person cannot really be held guilty for being for being an abettor to this suicide, because this was not intentional. Rather, abatement of suicide is one thing that is done over a prolonged time, that for quite a long time you torture somebody, quite a long time you try to influence somebody to commit a suicide or something. That would definitely amount to abatement of suicide. But any statement or words spoken in fit of rage cannot be considered as the abatement of suicide. Now, here another exception might come, as to we might say that maybe there are many people who are very sensitive for that matter, and who are very like they take anybody's words very seriously in many situations. Still, this sensitivity of particular person who actually committed suicide cannot be the reason why you are accusing another person of abetting him, which means that sensitivity can be a different thing, but still, if he was sensitive enough and the other person did not know and spoke something, definitely he cannot be held guilty for that matter. And thus, these are all the whereabouts about abatement to suicide, which should be very much clear, as there can be a potential question from this side as well. Now let's discuss that what do we have for news in flash today. First, Gandhi King Initiative has been passed by US Home Committee. So what basically Gandhi King Initiative is, that this initiative seeks to establish an exchange program between India and US to study the work of legacies of Mahatma Gandhi and Martin Luther King Jr. Because we know that both of them were huge, to say, ideals for the society, and then their work will be exchanged and their ideas will be exchanged. The bill is authored by American civil rights leader and lawmaker John Lewis, who was inspired to draft the bill after his visit to India in 2009 to commemorate the 50th anniversary of Dr. King's visit to India. Second, National Registry of COVID Patients. The ICMR, which is the Indian Council of Medical Research, in collaboration with the Health Ministry and All India Institute of Medical Sciences, which is AIIMS, has planned to create the registry to understand how treatment can be improved and to study the effectiveness of newer therapies. So basically, you should remember that there will be now a national registry for COVID patients, and who will be carrying it? It will be done by ICMR in collaboration with the AIIMS and Ministry of Health. Third, Mars 2020 missions with Perseverance rover. So it is a part of NASA's Mars exploration program. This should be remembered as to this is a project of which authority, and then the mission will carry a unique instrument called as MOSI or MOCIE, MOSI also it can be said, or Mars Oxygen ICRU experiment, which will for the first time manufacture molecular oxygen in Mars. So this also should be kept in mind, that this will be the first initiative wherein the first time attempt to manufacture molecular oxygen in Mars will be done by the Mars 2020 mission from NASA. Then the Perseverance rover will drill and collect rock samples after landing in Jezero crater of Mars. This should also be known that Jezero crater belongs to Mars. Then CATS, which is India, has decided to extend the conservation assured tiger standards across all tiger reserves in India. And then basically it is a conservation tool that seeks best practice and standards to manage target species and encourages assessment of benchmark progress. And as we know that India hosts 70% of world's tiger population, and that is why it is more important for us to launch such programs for the conservation of tigers in India. Then finally, blue macaw rescued in Assam. Basically, we should know that it is a hyacinth macaw, or the blue macaw is a parrot native to Central and Eastern South America, and it should be known that where are they endemic to? So it is to the Central and Eastern South America, and the IUCN status is vulnerable. So this should also be known. So this was all for today. We hope it was a good session for you. Stay tuned with LawSikho for further more sessions. Thank you.